Hello, everybody. This is Advocate Lucinda, your empowerment lawyer. Today, I want to talk about the power of the motion to quash. As you know, I am an advocate for using tools that are available to the plaintiff to assist the plaintiff in prevailing in their lawsuit. And there are many tools out there that you can use to assist you. One is the motion to quash, and particularly as it relates to when the defendant files a subpoena to obtain the former and current employment records of the plaintiff. So let's get started. Imagine that the defendant employer that you have sued issued a subpoena to your current employer and one of your past employers to obtain a copy of your employment records. The purpose of the subpoena is to obtain bad performance evidence that they can use against you in your current lawsuit. That's problematic on two levels. First, it's embarrassing. And secondly, it has an element of intimidation, doesn't it? And secondly, and sadly, the employer may even start eyeing the employee, the plaintiff, as a troublemaker, even as a whistleblower. And that's problematic too. So the plaintiff would want to challenge the subpoena immediately. And the plaintiff can challenge it with the motion to quash. Any person to whom a subpoena is directed or any party may file a motion to quash or limit the subpoena. This includes the plaintiff. The motion must be filed with the judge, and it must include the reasons why compliance with the subpoena should not be required or the reasons why the subpoena scope should be limited. A reason why compliance with the subpoena should not be required is because federal rules of evidence prohibits it. Under 404A, evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character or trait. Let me illustrate this point with case law. EEOC sued Lexus Serramonte on behalf of plaintiff Annie Wee. Miss Wee sued Lexus for discrimination and sexual harassment. Lexus sought information about Miss Wee's harassment claims or any other harassment claims filed by Miss Wee after her employment at Lexus. Why? To try to establish a habit of filing harassment claims. Lexus sought evidence of plaintiff's work performance at employers for whom she worked after she left Lexus. So Lexus subpoenaed these employers. And of course, plaintiff filed a motion to quash or subpoenas. You'd be happy to know that the court quashed the subpoenas, holding that work performance with other employers either before or after the defendant employer is inadmissible under Rule 404A of the Federal Rules of Evidence. It went further to say evidence of a trait or character to prove conduct in conformity therewith on a particular occasion is inadmissible. And you'll find that at page 223. And I will leave a link to this case in the description page of this video. I will also leave a sample motion of a motion to quash. Now, remember to tailor the motion to your case and always read local rules. I trust this has been helpful to you. And until next time, I'm Advocate Lucinda, your empowerment lawyer.